If you've been watching some of the big cases, or you're just interested in how the legal process works, this video may be for you. I'm going to go over anatomy of a lawsuit. Someone thinks someone else owes them money. They want to engage the legal system. How does it work from start to finish? Somebody somewhere right now is thinking, that person over there owes me money. Maybe they backed into their car, ran over their foot, breached a contract, said something bad about them, whatever. The person thinks, I'm injured because of this other person and they won't make it right for me. I'm going to take this to the legal system. They have a couple of choices, and one is they can just do it themselves. They can be pro se or unrepresented and file their own lawsuit. Really doesn't matter for what we're going to talk about later, but that's an avenue you can do. You still would have to follow all the procedures we're going to go over. Secondly, of course, you want to engage an attorney. There's kind of two ways to do that, and one is a contingency fee attorney, somebody who takes the case. They only get a fee if they win the case. They'll get a portion of that, or if it settles, they'll get some portion of that. So they have to believe in your case and the value of it in order to take a case like that. You can also hire an attorney on a billable arrangement, which for certain kinds of cases where the damages are speculative, but you still feel that you need to pursue your case, that's going to be the only way you get that case to be handled by an attorney. So when an attorney is looking at a case before they take you on board, they're looking at how strong is your case? What are the likely damages in your case? Can the defendants pay those damages? Those things are super material on a contingency fee arrangement, and they're also important on a billable arrangement to give you an honest assessment of what your case is like, plus you don't want to be bringing a frivolous claim. So if they decline the case, you can bring it yourself, or maybe you just go home and learn to live with the hurt. For our purposes, we're going to assume that the attorney takes the case either on a contingency or billable arrangement, and you move on to the next step, which is the attorney takes your case and does something with it. A lot of times what the attorney will do first is send a demand letter to the defendant and set out the parameters of your claim and say, you did this under any reasonable view of the facts. You owe this much money because of it. We're going to give you the opportunity to pay up before we file a lawsuit. It's going to cost you a lot of money, and you're still going to have to pay later, maybe pay more. Maybe we're offering you a discount if you'll do the right thing now. That's a demand letter. Now, when there's a demand letter sent, sometimes it does result in a negotiation, especially if the other side wants to keep it quiet or they know they did wrong. They may negotiate this out and never sees court. That's ideal, of course. They may also come back with some contrary evidence and convince you really don't have a case. And of course, that's rare, but that's something that could happen. Or they could simply disagree and say, we're not going to settle this case because we don't think you have a case. And so when that happens, the attorney has to decide at that point, am I going to let this go or proceed? But the next step would be to file a lawsuit. Of course, sometimes there's no demand package ahead of the lawsuit. You just file the lawsuit. There can be lots of reasons for that. You know they're not going to settle with you. You're up against a time limit. Just lots of different reasons where you may go ahead and proceed to a lawsuit. But for our purposes of anatomy of a lawsuit, we are now at the critical point of this thing. We're going to get this thing started in court. So your attorney will draft what is called a lawsuit or a complaint. That's the first pleading to the court. You're going to look at it. If you're the client, you review it, you make sure it's accurate, etc. The attorney will take it down to the courthouse. They're going to file it, and they're also going to have a summons issued. So those are the two important documents that you get at first. One is the actual complaint, which sets out what you think happened and what you think the court should give you for that. We'll get into that in a little bit more detail in a moment. And a summons, which is legal process from the court to the defendant that says a lawsuit has been commenced against you and you need to respond to it. So then you need to serve that on the defendant. You need to serve the summons and the complaint on the defendant. Some jurisdictions, law enforcement will help you do that or do it for you. You can have a private process server, certain kinds of mail, in person, whatever. There's different methods to serve it, but you have to get it served, and then you have to return that service to the court. And when you do, that starts the clock for the defendant having to do something in response. If they don't do anything in response, then they're subject to a default judgment, and you don't want that if you're a defendant under any normal set of circumstances. You do not want that to happen, so you're going to have to take some steps. The summons warn you, don't just throw this in the garbage because something bad could happen. On the other hand, if you don't get the suit filed or served in time, there can be bad consequences for that. If you don't keep the summons alive, you may run into statute of limitations problems depending on when you filed the suit. Some jurisdictions, you may even find that your case could be dismissed if you just sit around and never get it served. So once you're filing it, you're trying to get it served under a reasonable time frame and certainly within the limits. Get it to the defendant. So before we look at what the defendant has to do, let's look at what the sheriff brought to their door to them, the complaint, the main thing in the lawsuit. Let's take a look at what that is. Getting into the issue of the complaint, I ought to take a moment and stop and remind everybody that the United States has lots of jurisdictions, 50 states, federal court, special kinds of courts, different levels of courts within states. So the rules that apply in each one can be different. They can be different in material ways, but we'll just talk about generally what the circumstances are for complaints that you're likely to find in most jurisdictions that you would see one. So rules of civil procedure normally say that this pleading, the complaint, should be a short, plain statement of the facts and the legal theory and the jurisdictional elements that entitle you to relief. But that aspiration is generally not recognized because lawyers like to tell their stories. They like to write long things. So complaints can be, and frequently are, really lengthy. But we'll look in general what they normally have contained within them. First is the caption. You're going to see here what court this is filed in. You're going to see that it is a complaint. The first pleading in the case. You'll see the parties, the plaintiff who's bringing the lawsuit and the defendant. That's whoever they're suing. It can be more than one person on either side of that. They'll have a statement in the complaint saying who the parties are, usually where they reside, and they'll have a jurisdiction section so they can say to the court, here's how this suit properly belongs in your courtroom. The people in the suit are subject to your jurisdiction because they live here or they've engaged in enough actions that they're subject to your jurisdiction. And the type of thing that I'm suing for is covered inside of your jurisdiction as well. So the legal theory and the people involved, they all belong in this courtroom. So you have jurisdiction. Then you get to the lawyer's favorite part, which is the facts, which take that word loosely because this is just the plaintiff's allegations. But they will set out all the things that they think matter for this lawsuit that support their claim for relief. And they'll tell their story about how they're simply innocent, that they engaged in no wrongdoing, just a normal person living their life. And here's the defendant recklessly, purposefully, negligently, wantonly, whatever, terrible things they did. They ran over your foot while they were in the middle of a tweet, and they should have been looking where they were going. They said defamatory things. If you have multiple defendants, you get to use fun words like collusion and working together and under the cover of darkness. Conspiracy, things like that. So you want to tell your story if you're going to write this long complaint in a way that makes it look like here's an innocent person who really was wronged. Okay, you set the stage for that wronged in specific ways by the obviously bad acts of the defendant or defendants in the case. You get all these facts out. Important to the lawyer in doing these facts is you want to allege the things that are necessary for what comes later, which are causes of action or claims for relief, which are the specific things you're saying to the court here, the legal theories for why I deserve a judgment for money. So every claim like intentional infliction of emotional distress or breach of contract or whatever, it has certain elements under the law that have to be proved. So you at least want to get those elements engaged in your complaint to say, I had a contract, this person breached it, and you probably want to say what they did to breach it. Here's how it cost me some money. Now give me a judgment for that money. Thanks, I appreciate it. And some claims like intentional infliction of emotional distress will have more elements to it. There's lots of causes of action, lots of claims for relief, all kinds of legal theories and tort, contract, whatever. So your facts want to support the elements of those things. Then you get down into the claims for relief, and your lawsuit needs to have at least one of those. You've got to have one legal theory operating in your complaint at least that entitles you to relief if you're correct on all the elements, or else what are you doing bringing a lawsuit? And your lawsuit would be subject to a motion to dismiss by the defense for failure to state a claim upon which relief can be granted. In other words, you didn't plead the elements or a recognized cause of action under the law. So you'll set out your claim for relief, and a set of conduct can result in liability under more than one claim for relief, more than one theory. So you may have several causes of action, and certainly the attorney wants to put as many in there as they possibly can. So they'll set out the causes of action. Count 1, defamation, or count 2, infliction of emotional distress, and they'll recite. Usually they'll reincorporate all the paragraphs. They'll make sure they got the elements covered. They'll say they were damaged, and then they'll move on to the next cause. So you get all those out there, and you get to the end, and you do what's called a prayer for relief. And you say to the court, okay, all that stuff happened. I really want some money for this. You're probably going to say again that I want a trial by jury if you want one. And then you sign it, and that's the end of your complaint. One other note about prayers for relief, sometimes you see huge sums of money in the headlines, lawsuit for $100 million filed, or this, that, or the other. But sometimes you see cases that you think are big, and it'll say something like sued for $75,000 or $25,000, and you think, that case is way bigger than that. I mean, what's going on here? Why is it so small? In some jurisdictions, rules provide that in order to stop this kind of sensationalist media coverage of trials, that when you plead for relief, even if you think you're owed a lot of money, you only plead that you're owed an amount of money in excess of what the jurisdiction requirements are for that court. So say diversity jurisdiction in federal court, $75,000, you'll plead damages in excess of $75,000, even if you think it's $1 million. Same thing in some state courts, $25,000, whatever, that gets you into the court in that state that you want to be in. So you may not be able to write that headline, $200 million claim for hot coffee or something like that. But sometimes you can. There's exceptions, etc. But if you see a lawsuit that seems like it's for a smaller amount of money than you think this case is worth, recognize they may be operating under that rule that limits them from what they can say, in the complaint at least, about what it is they're looking for. So the complaint is filed. It's a beautiful piece of work. Anyone who happened upon it or would read it would be outraged and horrified at the behavior of the defendant and completely sympathetic to your case as a plaintiff. Shows up on the defendant's doorstep. Sheriff hands it to him, says good luck. Now the defendant goes, gets a lawyer, and says, what do we got to do about this? They got to respond is what they got to do, and they got to do it within the time frame that the summons says, although usually you can get that extended. Sometimes what they do is file a motion. In California, an anti-SLAPP motion can stop the case and cause it to be suspended until that motion is dealt with. That's not the same in every state. So sometimes they'll file a motion. Sometimes they'll go ahead and file what they're going to have to file eventually anyway if they can't get the case dismissed, which is an answer. And the answer can also have some motions included in it. And an answer will have all affirmative defenses included in it, typically, to make sure you don't waive any. The point of an answer is, not hide the ball here, to answer the plaintiff's complaint. So the defendant will respond to the specific allegations in the complaint. And typically, that's going to be something like, except for where you said where I lived and where you lived, everything else you said is completely untrue. This whole story you told is completely made up. I didn't do those things. You didn't do those things. You aren't hurt. I didn't cause it if you were hurt, all that. So you have to admit or deny the allegations, but usually you're going to be denying the material allegations of the complaint. And then there's your answer. If you feel like the person who sued you owes you money, you file also what is called a counterclaim, which is like a complaint, except for it's a counterclaim that goes to the plaintiff. Then the plaintiff would file a reply, which is like an answer. But let's just leave that out of the equation for now and say you filed your answer, you denied these things, so this suit is moving forward. There's not going to be a judgment on the pleadings because the pleadings show a material disagreement, and you got to move into what's called discovery. Discovery is when the parties exchange information. So you can request documents from the other side. You can request interrogatories, which are written questions they have to answer. You can demand electronic data. You can cause them to sit for a deposition, which is sworn testimony before the trial. You can, in a lot of jurisdictions, if you're an attorney, you can issue subpoenas to other people in your jurisdiction to appear for either a deposition or for production of documents and electronic data and the like. If it's not a party, the rules usually provide that you have to take steps to protect this non-party from undue expense or burden. I think that was the issue in the Johnny Depp case with the ACLU, that they spent a lot of time complying with the subpoena. So as they will in many courts, if the responding party says, hey, this is a really broad subpoena, it's going to cost me a lot of time and money to comply with it, they may order the party who issued the subpoena to cover the cost of that. In any event, you go back and forth, you argue over whether I got the documents I wanted, you argue over whether this is a fishing expedition, I shouldn't have to produce all these documents, this is just harassment. Argue. Eventually you run out of discovery and your case begins to appear on the trial calendar. So Before you get to a trial, also in a lot of jurisdictions, you may be subject to mandatory mediation. Sometimes you can get out of it, but what the court's doing there is saying, okay, parties, while you're in the middle of all this stuff, we're going to also send you to mediation. And you have to sit in a room, talk to each other. It may take a long time. It may not. Depends on how the mediator handles it. If he can bring you together, he or she can bring you together, that's what they'll do. And maybe your case will settle. At the very least, it may actually narrow and reduce the level of contention between the parties and sharpen what actually is at stake. Because remember, almost every case settles. Almost every case settles. The vast majority of cases settle. The vast majority of criminal cases, of course, plea bargain. So jury verdicts are the rare exception to lawsuits that are filed. So keep that in mind as you move through this, that at some point people get tired of spending money, or they realize maybe I'm not as strong in my position as I thought, or I want to get this behind me or whatever, and they'll end up settling the case. But if they don't, you start getting closer to the docket where you actually have a trial, and you get into motions related to the trial. You can have motions in limine to exclude evidence that you think he's going to try to introduce something that's terrible about me, and it's not fair and it's not relevant. So you can get a pre-ruling by the judge that says that's not going to be allowed in this courtroom if you're right on that. Argue over exhibits, argue over time frame, argue over everything. Remember, this is all argument. And eventually, you're on the trial docket. And so you appear in front of the court for that, and it's time to take your case to trial. So the court's not getting anybody out on summary judgment. You're sitting in the courtroom waiting for the potential jurors to come in. You're done with the extremely expensive process of discovery, and you're now entering the extremely expensive process of the trial itself. The jurors are called in, they're selected, they're put into a panel or whatever, and the attorney has an opportunity to conduct voir dire, which is they get to ask the jurors questions. And if the juror is, usually this is typical, if the juror has some bias on the face or whatever, the court may excuse them. But you also have elective challenges that you can make. You don't have to tell what the reason is. You'll have a certain amount of those. So you sift through some jurors and you finally end up with a panel that's acceptable, or at least you've run out of the ability to challenge it. And those jurors are sworn in, and it's go time. You do opening statements, you call witnesses, you argue more motions outside let me tell you, outside the presence of the jury, lots of motions, lots of arguing go on there. They don't let the jury hear that stuff. They just want the jury hearing the evidence and testimony. They don't want the jurors hearing the arguments. That's why oftentimes, too, when attorneys object in the courtroom, the objection is very limited, because the judge will get very frustrated if the lawyer tries to do a speaking objection where they begin a long argument of the merits of their objection. If they want to do that, sometimes they'll say, can we approach? The judge will let them do that. Often they'll go up there and make a little bit more of an argument. Then the judge will make the decision. If it's a really big deal, they'll wait and do it outside the presence of the jury, or they may even stop the case and have the jury leave while they have this big argument. But usually the judge will just go ahead and rule at that point. No, I'm going to allow that, or no, that's hearsay, I'm not going to allow that. That's how it normally occurs. Some jurisdictions you'll see the lawyers walking around like Perry Mason or something like that, leaning on the jury box and getting up into the witness's face. That's great TV, but a lot of jurisdictions, probably most, they don't allow that. In some jurisdictions, you have to sit behind the table while you're questioning the witness. You can only get up to take the witness an exhibit or change an exhibit or something like that and come back to your seat. You can't go around just monopolizing the place like you're in a Shakespeare play. So sometimes if you see them sitting at the table or at a lectern, that's why they're doing that, because there's some limits on the attorney's behavior. Trust me, that's a good idea. So more motions, etc. You finally finish, you do your closing statements, and the jury goes in for deliberation after hearing the jury instructions, which the attorneys have also argued about with the judge and finally got a set that they've objected to or agreed to that the judge is going to deliver. Those are really long. Often they're pretty confusing, and the jury has to try and listen to all that and understand it and take it back into their deliberation room and then come up with a verdict. And so they come back with a verdict, and maybe that verdict is, nope, you didn't make your case, the other person is not liable. That's the end of it unless you appeal. They may come back and say the person is liable, and then that person can appeal. But in the course of that, now they've got a money judgment against them that the judge will enter. And so that judgment can be collected on. So you have to then potentially even do discovery after the case is over to find out, well, where are your bank accounts? What house do you own? Where's all your stuff at? Because you may not know those things ahead of time, and how you're going to collect on your judgment until you find that out. Collection of money on a judgment is no easy thing. Getting the judgment is great, but that's a big ordeal. Obviously, you may have to go through additional discovery. You may have to chase it across state lines, which would cause you to take your judgment into the states where the assets are and appear in court there to try and get your judgment domesticated in that state so that that state will engage its resources or allow you to engage yours to collect the money in that state. The states respect each other's judgments on the full faith and credit clause of the Constitution. So that's not an issue, but it's still an expensive, time-consuming process to even try and chase this money down. So again, settlement is the word here. Sometimes that occurs right in the middle of trial. The parties will have agreed finally to settle this case. The judge will call the jury in and say, you don't have to do this anymore. It can occur while the jury's deliberating. It can occur after the jury comes back. It can occur while the appeals are pending, because depending on the situation, it can always be worth it to make some kind of concession just to get this over with, because there is nothing easy through this whole process. So this can take years sometimes to get through this, from the time you file your complaint until you get your judgment. And then on top of that, you got to try and collect on the judgment. Here, the sheriff is empowered to help you do that, and they will put a fee on top of that, and they can seize bank accounts. They can come to somebody's property and take their stuff away from them. So it's not good either if you owe the money, because you've got law enforcement chasing you down to take your stuff away. So you really do want to try and figure out how to handle this. You want to pay, you want to move to an island or some other country or whatever. I don't know what you're going to do, but you've got a problem if you got a judgment against you. If you're judgment proof, how it's called, in other words, you don't have the assets to pay the judgment can settle on the books for quite a while, say 10 years in some jurisdictions. It can be renewed again, maybe for another 10 years. As the plaintiff waits and watches in case you inherit a bunch of money or you win the lottery or something like that, or you found out about this bank account you didn't know about at the time that the case was finished. So they can settle on that judgment. Of course, it's going to affect your credit, etc. So it's a big deal to have it against you, and eventually it gets collected or it goes away. So you start out frustrated that somebody hurt you. You go through a frustrating process in court. You get a judgment. That's a good day. And you have a frustrating process to collect. This is why most cases end in settlement. Sometimes they don't. Sometimes they go all the way to the jury verdict, and sometimes they go to collections. And this is a big mess for, say, in the Johnny Depp case now with the Amber Heard situation. She wants to appeal. She would like to not be collected against, but to avoid that, she has to file a suspension bond to stop collection even during the appeal. Even if she's right on the appeal and she's appealing, if she doesn't file the suspension bond during the appeal, Depp can go after her resources, her assets. So she's at that final phase now where it sucks to be her, but it also kind of sucks to be Depp, because what's he going to do? Keep paying lawyers to chase after this amount of money from her? And if you've heard the amount of money being charged in this case is quite high. So it still could happen that it gets worked out in some way, but this is the rare case where it seems like the behavior, particularly on the defense side, from a legal posture and from things she says, it's like, how can we make this as bad as possible and drag it out as long as possible? It doesn't seem to make any sense. So it's a very atypical situation there. So I hope this has been helpful to show you how you go from being somebody hurt you, to getting into the legal system and what all the steps are that occur in that, until finally one day the jury comes back and says you win and you still got work to do. Thanks.